Hello, this is Robert Perkins, the immigration professor, and welcome to part 2 of our series on unlawful presence and waiving or pardoning unlawful presence. You can see all of our informational videos on immigration topics on our website, www.immigration-professor.com, or if you have a specific question about a case, we represent clients all over the United States on immigration matters, and you can call us at our main office at 310-384-0200. So in the last video we talked about what is unlawful presence, and we talked about the fact that it is a bar to people immigrating to the United States or even getting a temporary visa like a tourist visa once they've been unlawfully present for 6 months or more and have to leave and come back in. So before we get into how to get out of unlawful presence or how to waive or excuse it, I want to mention a couple of common cases where it doesn't apply. And we have an article about this on our website on immigration through marriage. One type of case, for example, let's say someone enters legally on a tourist visa, it's expired, and they've married a citizen. That person can process their case in the United States because their original entrance was legal. So unlawful presence, as we said in the last video, is only triggered when someone departs the United States or has to depart. So people that came in originally legally, even if their visa is expired, they don't have a problem with unlawful presence because they are able to process their case in the U.S. When unlawful presence comes in is when someone came in illegally and they have no other way to get their status or process in the United States, and they have to leave, triggering the unlawful presence bar. What does that person do? So we'll talk a little bit about that. So the law does allow for unlawful presence to be waived. And there's 2 specific waivers or pardons, as you may think, of unlawful presence. There's one for people that are visiting on temporary visas, such as a work visa, a student visa, or other visa. And it's found at section 212D3 of the Immigration and Nationality Act. This is a general waiver where the government can waive or pardon or excuse any type of activity that would normally bar somebody from coming back in. And people have used that to excuse unlawful presence. So let's say somebody was here unlawfully for a while, they've left, triggering the unlawful presence bar, and they want to come back in or work and study. They can apply for this waiver. And this is a very general waiver, and it allows the government to consider all factors in deciding whether or not to admit that person. What type of job are they coming into? How bad was their immigration violation? Do they have other equities in the United States, like a spouse or kids here, things like that? They can then come back in on a temporary work visa, such as an H-1B or an F-1, if they are granted this waiver or pardon. And the waiver or pardon is valid only for a specific period of time, typically 1-year increments. So that's the waiver as it works for temporary visas, like work visas and such. So let's talk about it in a minute, about how does this waiver apply in the most common case, which is green card cases. When someone's married a citizen, they want to come back to be with their wife or even their kids who are U.S. citizens. I want to mention again that all of my videos on immigration topics are available on my website, www.immigration-professor.com, or if you have a specific question about your case, call our office at 310-384-0200. I'm going to grab the eraser here. And let's talk a little bit about the waiver in the most common type of case, which is usually a marriage case, although it can be any relationship, father, son, mother, daughter, family immigration kind of case, or even an employment immigration case. To get a waiver of unlawful presence, you have to show extreme and unusual hardship, not to yourself, but to your spouse, parent, child, is a U.S. citizen or permanent resident. So basically that's the problem, is you have to show an extreme and unusual hardship. What does the law consider when looking at extreme and unusual hardship? What does that mean? Well, the first thing I want to say is that all the different things it means can be combined. In other words, if the spouse or child has hardships, those hardships can be combined. One thing I want to mention is that if you are the petitioner and petitioning for your parent as a son or daughter, that you cannot get this waiver. You're not qualified. So I want to make sure that that's clear. But in any event, in terms of what do you need to prove, you can show medical hardship. For example, let's say somebody has cancer and they need their spouse to help them with their medical treatments and to provide financial support and other support. That's a classic case of medical hardship. The other type of hardship is psychological hardship. Of course, anybody would have psychological hardship to be separated from their spouse. But what if this person's particularly vulnerable? We had a case once that got approved for a waiver or pardon where the U.S. citizen's spouse had actually lost two other spouses had died on that person. So we showed that if he was not able to have his current wife come back in, that would be an incredible loss and hardship to him from a psychological standpoint. Another type of hardship is financial. Let's say the immigrant is providing most of the financial support for the family. So financial support or financial hardship is also a factor that's taken into consideration. Another one they look at is community ties. In other words, what would it be like if the U.S. citizen had to go live in the foreign country? Do they know the native language? Are they able to survive? So those are some of the most common things that are looked at. And the law is fairly broad in that it allows the embassy to look at any other type of hardship. So this is my video again on the waiver of unlawful presence. We've talked about what it takes to show it, the extreme and unusual hardship. And in the next video, we'll talk really briefly about the procedure for getting it. You can see all of my informational videos on my website, www.immigration-professor.com. Or if you have a question about your case or need representation, and we represent people in all 50 U.S. states and also overseas at embassies, you can call our office at 310-384-0200. So that'll conclude the second video on unlawful presence, and I look forward to seeing you for the third video. Thank you very much.